Good morning, and thank you very much for joining us. I am Iyori Folarin. I'm glad you could make it. Okay, well, let's look at, wanted to look at the matter of the EFCC. Quite frankly, it's not a matter of the EFCC. It's a matter of 16 state governments, suing the EFCC to court, saying that their very existence runs foul of the Nigerian Constitution. So that's where we are, and no doubt you would have heard about this. So we thought we'd just look at that. Although, I'm sorry, you see, my guest this morning is Evans Ufeli. He's a legal practitioner. Thank you very much for coming on.
Good morning to you.
Yeah. So I hope I haven't mixed it up a bit in the sense that there's also the PDP, crisis.
Yes.
So I don't know, what were you prepared for?
Yes, the EFCC.
It was the EFCC issue, I thought.
That's what I was called for.
Indeed. So thank you very much, because oftentimes people with multidisciplinary specializations are able to handle a number of topics that we have on hand. But yes. Now going to the EFCC matter, the first thing that comes to mind is that the EFCC that we're talking about now, 16 state governments reportedly, wanting the court to pronounce upon, their plea. The EFCC wasn't established yesterday. And so it's been over 20 years. What does that say to you, first of all, that this matter is coming back into the limelight, where governors think that the establishment of the EFCC in some way, shape, or form infringes upon, their rights?
Yes, there are a number of issues that were outlined. First, let's start from the beginning.
Okay.
The source of the EFCC, its existence, how did it come about?
Yes.
It came about as a result of the UN Convention Against Corruption. That convention was what was reduced to the EFCC Establishment Act in 2004. Okay? Now, once that act had been brought into law, Section 12 of the 1999 Constitution as amended have certain protocols for which any law that sprang out from a convention must go through certain protocols. Now, one of the protocols is that the National Assembly coming up with that law will require the concurrence of the State House of Assembly for it to become a formidable act of the National Assembly for the purposes of law.
Okay.
In the case on that reference.
Yes, okay.
In the case on that reference, the EFCC Act, the State of Assembly's concurrence was not sought and obtained.
Indeed.
No, was not sought and obtained. That is why this action is now, it does not matter how long EFCC have existed. In law, USC Food versus Mark Ford, Lord Dennis said, if a matter is void in law, it's a nullity. As you cannot put something on nothing and expect it to stand, it will collapse. Okay, so if you look at the case of Mobike, Joseph Mobike versus the Federal Republic of Nigeria, that the foundation of EFCC was established by the Supreme Court itself, that stated that the formation of EFCC is from that convention, okay, the UN Convention Against Corruption. It is that document that was reduced to the EFCC Establishment Act. And once an international law, or once a municipal law takes its roots from an international law, okay, because Section 12, subsection 2 of the 1999 Constitution says that the National Assembly have a right to make laws on issues not contained in the exclusive list, let's say the exclusive list, for the purposes of domesticating a treaty. You understand? Then Section 12, subsection 3 of the 1999 Constitution went further to say that when such law, such treaty, or any law that emanates that have its root from a treaty comes into existence, you need the National Assembly's operation to the extent that a Houses of Assembly concurrence is required in the case under reference. But in this case, it It's not there. That's one of their claims. There's another claim, too, that funds appropriated to states, the federal government have no right whatsoever, under any guise, EFCC or whatsoever, to tele-guide how those funds are used, spent, because of the doctrine of separation of power, the doctrine of federalism. Okay? So the arguments are there. Now, it is for the court to look at it effectively and see the merit. But mind you, the court, there's a precedent already emanating from the same Supreme Court that have established the source and formation of the EFCC, which by implication will mean that if this go through, it will by implication mean that all convictions that EFCC have secured and trials it has undertaken from inception will be invalid.
Really?
It does not matter.
There is that aspect to it, you are saying?
Very well.
Because the very body that caused that particular situation can be regarded as something.
Yes.
And if by law it is now said that there is actually no thing.
Yes.
Because that EFCC that brought all of this about was unknown to law.
Yes, because it's not properly constituted. There must be a reconstitution or a total scrap of it.
That's the play of the 16 states.
Yes.
You know,
that
well,
it should be.
Two of them are asking for consolidation.
They came by application to join the suit. Okay, so they are meant to go consolidate, and then the court will hear the matter in a date on 22nd of October.
All of this sounds sort of understandable, in quotes, until you add the context that the EFCC Establishment Act was first enacted in 2002, and then it was amended in 2004. Now, here we are in 2024.
Yes.
What does that in itself say? You know, sometimes time is of essence and sometimes it's not. But in this case, the fact that, look at what's been happening in the EFCC, look at some, highfalutin cases, especially, look, I think this matter originally, if you go back to the source, was initiated by the Kogi State government
yes.
through its Attorney General.
Very well.
Now, Kogi State has featured in recent times again.
Very well, that's true.
You know, so I don't know, what does this say to you? Is it just a series of coincidences, or what exactly? Because the implication of this is that hands off. What we're saying is that we are empowered by law to handle our affairs without, without any intervention from the federal government as this. So what does this now? What does this say when you put it within that context?
There have been insinuations that the Kogi State government went to court because of the recent case between the past governor Bello and the EFCC. Insinuations are there. People are saying, I'm listening to a lot of people make that comment. But you know, the truth is that does it matter whether there was a problem with them or not? What matters is that a case has been instituted and some states have joined, have applied to join, and they have been joined. So whilst they have been joined, we have to look at the constitutionality or the matter under reference. Because the truth is that when you don't constitute an institution properly, it does not matter how long that institution endures. It will get to a point where people will challenge the veracity of the constitution of that institution, whether it was done properly or not. Remember, democracy was just fledgling then. We're just into the return. That's the return to proper democracy now.
Yes,
that has taken the longest.
President
Obasanjo. Yeah, which has taken the longest now. So those oversights may not have been properly guarded. But as we speak now, there's a need for the Supreme Court to make that pronouncement as to the legality or otherwise of the EFCC. And if you look at the fact on ground and the precedents on ground, the EFCC itself, the Court of Appeal, the Supreme Court itself have made, far-reaching precedents before now, upon which this case is even based on. Okay, so it's our constitution, because if you have an international treaty, you can't just ask the National Assembly to just absorb it into law, one-off. Okay, it must go through that process and that procedure.
As you people say in law, the action at the time, back in 2002, was erroneous on the part of...
The formation of the EFCC itself, yes. The formation was incoherent because the National Assembly had played its part, its own role, by reducing that convention to the EFCC Establishment Act, but it did not seek and obtain the concurrence of the State House of Assembly at the time, which means the process for the commencement of that law was incomplete, was incoherent.
Okay.
And so that argument subsists.
If we were to pursue this for a bit, I wanted to ask you, let's look at some theoretical scenarios. If indeed what they are applying for, what the states are applying for, indeed the Supreme Court says you got it. But before I come to that, good morning, Mr. George. Thank you for calling in.
Good morning, Ufeli.
Thank you for calling. Good morning.
And good morning to your guest.
Yes.
Good morning.
Ufeli.
Can you hear me?
Yes, we can hear you. Thank you.
Ufeli, I've been listening to your guest and his argument, and I believe he's an activist lawyer, judging from the comments he has made in the public space in the past. This argument of the 16 governors does not hold water. The lawyer there says that EFCC came into being as a result of a resolution or an international convention which was domesticated in Nigeria as recommended to other countries as well. Do we need an international body to tell us to fight corruption in our country? In other words, if there wasn't that convention and our National Assembly passes a law establishing an anti-corruption body, would it be illegal? The answer is no. These governors, if the EFCC was not running after them because of mismanagement of funds, would they have ganged up together now and be saying EFCC should be scrapped? Is EFCC activities centered on governance alone? The EFCC is called Economic and Financial Crimes Commission. It includes any other financial crime. Some bank executives have gone to jail through the activities of EFCC. Yahoo boys have gone to jail through the activities of the EFCC. Those ones have not ganged up together to say EFCC does not have legal status. But because governors have the money of the people, they feel that they have the power to challenge it. Let us see what the Supreme Court is going to say on the matter. Because the lawyer there says, if the government gives states money, they don't have a right to monitor how the money is spent. Is that money their own or our own? When the money that is given to them belongs to the people, the federal government, an elected government, has a responsibility to ensure that what that money is meant for is what it is used for. You can't tell me that after you have received the money, you can squander it, you can steal it, you can do whatever you like with it without being questioned. That's not in the spirit of any democracy that we know.
All right.
So indeed, I want to see how far they will go with this argument. Instead of these governors to brace up and do what will not make them become guests of EFCC after their tenure, see what they are sitting down to contrive. It's very disappointing.
Indeed.
I'm really disappointed. But let's see how far they can go.
Okay.
Thank you.
Thank you very much. I don't know if there's any part of that you wanted to
let me correct one of this. He said, I said, if the central government have deployed funds to state government, that is the prayers of the claimant in the suit. part of their prayers. First, the constitution of the EFCC being wrong, and two, the fact that in the spirit of federalism and the structure of a federation, the federal government, once it has, given the state their resources, it divests himself of authority over such resources. It cannot go and teleguide same, through any guise, whether EFCC or whatever it is under the law, because the state are supposed to be autonomous. You see, the essence of this, nobody is saying the EFCC have not performed over the years, or whether because some governors are in the EFCC net or whatever. We're saying that the proper thing ought to be done by law, If the constitution was faulty, no matter how perfect they perform or how good or how powers they have, it's just like a judgment. You write a judgment, no matter how far-reaching the judgment is. If the court has no jurisdiction, it goes to no issue. If an institution in like manner is constituted in a way that falls short of the provisions of the ground norm in the country, that institution cannot subsist because of its foundation. Otherwise, you'll be using illegality to operate as a country. So we don't need that. So the court will look at the merit of the matter dispassionately. Whether anyone have problem with EFCC or not, it's not the issue now. We have gone past that. The issue is we are going back to the root of this institution to reassess its formation.
More than 20 years after the event.
It doesn't matter.
I know, you said so.
It doesn't matter.
More than 20 years after the fact. Perhaps that was why there was, an aspect of, activism, being impugned on aspects of your response. Look, if we are all, it was established for a particular reason, and corruption is part of it. It's the commission, the EFCC, is to combat economic and financial crimes.
That's fine.
So
very okay. I mean,
wherever you see that from, but for some people to now look at the law and say, the law can be applied in such a manner, and the long and short of it is to, take away from the Economic and Financial Crimes Commission perhaps the ability to even perform this very said fact, which is, combat economic and financial crimes, indeed, reading from their own site themselves, thereby enabling the Commission to prevent, investigate, prosecute, and penalize economic and financial crimes.
Where their function and objective is properly defined. They have been doing, we've seen what they have done over the years. Nobody said they are not doing, but are they properly constituted is the question. Their constitution is being called to question. You know that before now, they don't swear in service chief. Before now, until Festus Keyamo SAN, current Minister for Aviation, went to court and challenged it. And for how long have they been doing that without? And the court corrected it. That is what I'm saying. This is not vendetta or
it's a matter of
trying to get back at EFCC or whatever.
The principle of the thing.
Yeah, the principle of law. A lawyer that understands what it is to secure the fidelity of a legal system and the institutions know that when a matter is void, the law is a nullity. When you have an institution that has gone through an inchoate formation, what it means is that that defect must be cured. At some point in human history, it must be cured.
The word incoherent, when lawyers use it, people like, professionals like you, it's a very, very big word.
Yeah, what it means is incomplete.
I know what it means. And by virtue of the incompleteness, there is actually nothing on the ground. You have to sort of put your mind, those who are non-lawyers, to put their minds to them saying that it was like a ghost-like affair because it was incoherent. There is no substance, and therefore you can't grasp it, you can't think of it, you can't do any work with it.
That is it. But you see, if the Constitution in Section 12 had not made that provision,
okay, the Constitution itself.
Yes, because the Constitution is supreme, and the law said its provision shall have a binding force on all persons and authority throughout the Federal Republic of Nigeria. All persons and authority. It doesn't matter whether you have problem with EFCC or not. Okay, so we must, obey that law, okay? And part of obeying the law is to look into the formation of the EFCC. To get it clear, they too will become rest assured that perhaps this institution was not properly constituted, or it was actually, whichever way the court turns. I mean, when people go to court in Nigeria, it's unfortunate. People believe that it's fight. For lawyers who don't see it like that, we see it as a way of developing the jurisprudence of the state, much so that there is a precedent on the case. Joseph Mobike versus the Federal Republic of Nigeria. The Supreme Court itself defined the formation of the EFCC. Which other court in the land can dispute the resolution of the Supreme Court? None. So, on the basis of that, take it back, go to the formation. Now, did the National Assembly actually comply with the Constitution in that formation process? They didn't. So that is where the case is.
And it doesn't matter, because that's implied in what you're saying, it doesn't matter the nature of their work. For instance, as you know, money laundering is in there, advance fee fraud, failed banks, recovery of debts, not to mention what the Constitution calls miscellaneous offenses, and then criminal code and penal code. Now, that they brought a specialist agency at all, that maybe I shouldn't say they, when we, whether it is incoherent or not coherent or whatever, these are before the Supreme Court to pronounce upon. Yeah. When they brought it was, I'm sure part of it was that the court system is overburdened. The court system is bad enough as it is, so we probably need, although I don't think the term was used, we need a fast track, a specialist unit. Do you think that they could have had specialist courts as well, as opposed to coming to the general courts where everybody
That argument is still there. We have a lot of persons who have made that because the conventional courts are crowded.
Yes.
So when you take these cases there, it's sometimes because of the passage of time and the long adjournment and the congestion of the court, it affects the efficiency of prosecution and the rest of that. That argument is there. Even for electoral offenses, the argument have been put forth that we need special court to prosecute electoral offenses.
Yes.
So we'll be having that. But the truth is that in Lagos State, we already have special courts that try EFCC matters and the sexual offenses matter. When you go to the High Court here, you see they have a section for that, specialized already. Okay. So this is to enable for quick dispensation of justice. So in Lagos State, we already have that. Other states may have to, copy, because when you talk about the law, Lagos State is ahead of every other state. Okay. When you talk about the law, even include Abuja does not come close. Okay. Because of the fact that
the administration of the law.
The administration of the court system, the entire judicial system, and all that. In Lagos State, we have the Office of the Public Defender, okay, which you can't find in many other states, and even though the federal government have their own legal aid council and all that. But let's not be sentimental about this issue, because that is what the problem is. And I heard the caller loud and clear. He has a point in what he's saying, but there's also another point too, and that is a point of revalidating an institution that's not properly constituted. We have to go there. We have to go there for so many reasons. One, he that comes to equity must come with clean hands. Okay, and there must be a proper formation of the foundation of every institution in the country where you have an instant law. If it was a municipal law that came through just municipal arrangement, okay, then the State House Assembly, you don't need their concurrence, except when you are amending the Constitution. That's when you need the concurrence of the State House of Assembly. If you're not amending the Constitution, the next point where you need their concurrence is when an international convention has been reduced to an establishment act.
Indeed. So that
by virtue of that influence, you now need the concurrence of the State House Assembly to recalibrate, to give it essence.
So, what therefore is now before the courts to so declare, that, and because this was omitted back in 20,
2003,
yes, 2003, 2004, 2, 3, and 4. That stage was omitted. So we should do away with it or correct the anomaly.
The Supreme Court will take a decision as to what to do.
Because it is
the parties already have their prayers.
They're asking for the Supreme Court to tell them how to go.
Yes, that is why the average Nigerian who is a non-lawyer should take up these legal materials and get legal reasoning. It's not for any purpose. We're just here to educate society. Whichever way, there was a time in this world when someone said the earth was spherical in shape, when the whole world had agreed that it was flat. He was killed, he was hanged, Galileo. Later on, scientists found out that it was actually spherical. The man has been killed a long time ago because of his argument. So let's not shut our. We shouldn't be closed-minded as a country. This is not to impugn on EFCC or to make them irrelevant or whatsoever. We're saying that there is a problem somewhere. And if you have a problem, the best thing to do... It
doesn't matter when this problem came about. Whether it's...
It doesn't matter.
It doesn't matter. It took 20 years, more than 20 years.
It doesn't matter.
After the EFCC had come into...
As long as there is a defect somewhere, as long as a defect somewhere, you can't keep building on it because one day it will collapse. When the foundation is not good enough, all you build on top will collapse. Okay, so it's better, it's still early in the day, 20 years after. It's quite early to do that.
Suddenly realize that, you know what, this EFCC that is troubling us, as a matter of fact, there are technical aspects to its very existence, and we can explore those technical existence.
Very well. We can. There are other institutions that are going to come to play in this country. Today now, we're already facing the astronomical age because the information age is almost exhausted. We are going to the astronomical age. You are going to be having Space Force. In some countries, they have Space Force already. You have Air Force, you have the Navy, you have the Army, you now have the Space Force. Are we not going to come to that level in Nigeria where we're going to have, are we not going to, make a law, an extant law to bring it into existence? Are we not going to go by the Constitution? And if it's influenced by an international treaty, we need to, do it the right way to have it come into existence. There are many institutions that are going to come in the future. So now is the time to look at the watershed. Everyone that have been constituted wrongly must be corrected before we get into the future.
Okay, and it can be corrected.
Very well.
There are ways and means. There are devices.
The Supreme Court will make a pronouncement. The states have their prayers before the court already, which is far-reaching, which extends to the issue of federalism. Because we have refused to do proper federal structure, the issues on the exclusive list, you see that many states are going to plug them one after the other. The issue of power, before the President Buhari left office, he signed that every state can generate, distribute, do whatever it is you want to do. The Attorney Generals of different states have not advised their governors effectively to have a legal framework to those effects. But there's a law already on ground. Yesterday, the national grid collapsed. Okay, why should the entire country be plugged into a national grid? States can have their own. The ones that are close to wind can use wind. The ones close to the sun can use solar. The ones close to the water can use the dams. So it's win-win for me. This case is win-win for me. Anybody that sees it as a win-lose or vendetta is not looking at it proper. I should look at it again. It's a win-win for all of us. It's a learning curve, even for the EFCC.
Because it will develop the...
It will develop the jurisprudence and it will give us good precedents that we will use in the future to advance our laws.
Well, yes, all of that is always good. And I think all lawyers want what you've just said, advancing our laws. But relating to this particular case where state governments are suing the EFCC, not all lawyers are in agreement on...
but you can't... There's no foreseeable end in law.
Yes.
You can't bring all lawyers
see it from that point of view at all. In fact, there are some who say that it's just a ruse. This is a ruse. A bunch of people got together of like mind, like interest, and said that we are being... our desires are being thwarted. We are being harried in, in what we would like to do. And so we need to get rid of the very agency that is causing us all this trouble. And that is also, without prejudice to what you've said, that is also uppermost on most people's mind. In fact, the first caller who had said that what's this all about? Why are we playing? Why do we play these games with lawyers? Lawyers come, they are part of us. They're part of us. They know us. We know them. But they also happen to be officers in the temple of justice. So that's when they now go and bring all these. No,
but if he reads the Constitution,
he has read it. He knows the Constitution.
You are speaking for him. Yes. If he reads the Constitution, he will see the need for what is ongoing. It's important. It's important what is ongoing. We have to make sure we have an institution properly constituted. We can't do without that as a nation. We can't do without that. It doesn't matter how long the institution have been created. Doesn't matter. I cited an example when service chiefs were, not being sworn in and all that. I cited that, and today we are better off of it because we have a better way to go about it. So we can always do the same to institutions, not just the EFCC. It could be any other institution that is influenced by international convention. We have to do it proper.
Okay. We have to air all of these things so that in the interest of transparency and, as you said, the development of jurisprudence,
yes,
and so that we are all seen to be doing the right thing. And as you conceded, one is listening to you and your legal colleagues who are opining, commenting on this whole matter. Well, I'd like to thank you for coming on and giving us this particular perspective of the matter. It's interesting. In fact, some lawyers are even going as far as saying that we have to be careful because it is actually before the courts, and so they don't want to go one way or the other.
There's no law that says you cannot talk about it, but you shouldn't preempt the outcome.
Indeed.
Yes, because the role of the media in Section 22 of the Constitution is to hold government accountable to the people. So issues in the news, you can discuss them, but you shouldn't preempt the outcome of the court.
Indeed. Well, I want to thank you very much. Thank you very much for coming along.
Pleasure.
We always appreciate it when you come. Okay, so stay with us, please. We'll look at. We'll take a break. We'll be right back and.